One unusual feature of corporations is that sometimes they can be so big and so well funded that they can enter into contracts with national governments on an even footing. In this case, Amoco, a Swiss company, was financed by Amoco International Finance Corporation, an American company, to enter into a joint venture with an Iranian company to drill for oil in Iran. Sadly, not too long after all of the initial investments had been made, the government of the Shah of Iran was overthrown, and Iran went from being a relatively modern, progressive nation to being a fundamentalist Islamic backwater. The new regime took control of all substantial assets in Iran, including the joint venture assets. Amoco International Finance Corporation took action against the nation of Iran itself for breach of contract and for unlawfully taking the Amoco assets. Reading the judgment, one gets the sense that the judges were not at all happy about the conduct of the Islamic Republic of Iran in expropriating or taking private assets. However, international law is always subordinate to national law, and everything which the Iranian government had done had been in accordance with Iranian law. The court was therefore required to find that there had been no breach, and that the expropriation of the company by Iran was lawful. However, that was not the end of the fight. There is a principle of international law that when a nation takes away the assets of a foreign national, including a foreign corporation, proper compensation must be paid. In this case, no compensation had been paid at all. The court found that because Amoco had been in a 50-50 joint venture with an Iranian company, Amoco should be compensated with 50% of the value of the joint venture as at the date it had been expropriated. The court said, "The government of the Islamic Republic of Iran shall pay to the claimant, Amoco International Finance Corporation, a compensation measured at 50% of the going concern value of the joint venture company." From this case, we learn that a large transnational organisation has a limited legal personality in international law, and while such a corporation belongs to the nation of its incorporation, or the nation where it conducts most of its business, the corporation can sue in its own right without needing the national government to step in on its behalf.